identifying material. It's often reflected in these private agreements, but for trade secret protection, there is nothing to file with any governmental body.
So the trade secret is between me and the person that helped me develop it.
That's correct. And anyone who's helping you to exploit it, whether it's internal employees or outside consultants helping to manufacture or market it.
Okay. So I have those two. Now, what about a copyright? I've heard that you could take your code and put it on a bunch of pages and send it into the copyright office to protect the code. Is that true?
It's certainly better than doing nothing, for sure. A copyright is intended to protect a particular expression of ideas. It does not go as far as a patent.
Okay.
It's far better than nothing. It's far cheaper than a patent, but for true market exclusivity, a patent is optimal.
Okay, so I could take this code and bring it to an attorney and have them file the coding or the functionality. Is it how it's used and how the app works is what I'm protecting?
Whatever is described in what are called the patent claims, that are the specifics of the patent application. There are different types of patents that could be pursued, and when one talks about a mobile app in general, it's really impossible to say exactly which type is appropriate. That's where the personal involvement of an attorney that's dedicated to advancing your cause is absolutely essential in these situations. Somebody needs to take a look at what you propose to do, take a look at what others have done. More importantly, take a look at what the Patent Office and the courts have done in response to other filings and figure out the best way to present this. One, to maximize the chance of a patent actually being issued, and two, to maximize the protection that that patent buys you in the marketplace, and three, to maximize the likelihood that all of this would be sustained if you're challenged in court.
Okay. I understand that with the Walgreens situation, that Walgreens has this functionality of somebody going on and filling their prescription on their mobile app and it goes to Walgreens and they deliver it. So that to me is like a process that's being protected, and I respect that. If I come up with a game that you're flinging birds across landscape and you're landing on a building, games to me between the Walgreens of the process of filling prescriptions versus gaming apps, what's the gaming apps can be protected?
Well, certainly there can be some sort of trade secret protection for the specific coding, and there could certainly be some trademark protection for the identifying marks. Whether there's actually a patent for Angry Birds or any of these other bird games, I'm not sure.
Okay.
Because under the patent statute, the Patent Office and the courts ultimately have to determine that the subject matter is useful in some way and is not obvious. There are statutory and common law standards for these things, and your distinction between a prescription refill technique and a bird flinging game, I think, is very helpful and illuminates the requirements of the statute.
Okay. So I've seen many games, there's even shooting games that kind of like the same thing. You have a gun and you're shooting, enemies and all these different things. So I don't know how much there is of patent protection out there for those type of things, but they have a good name, possibly is what you're saying. They have a good trademarkable name. They already have a presence in the market where if you have a good idea for an app, you would be able to present to a development company or an app company that already has distribution for you to collect what's called a royalty. So it's almost the same thing as having a physical invention product that you came up with and having this app. So that's a possibility.
It may be, with one important distinction that comes into play in some situations. Trade secret protection is often very valuable. It's perpetual as opposed to a 20-year monopoly with a patent. However, the trade secret protection does nothing to protect you against a third party independently developing the subject matter. Now, if no one does independently develop it, you're fine. But if someone else does, then you are not fine. With a patent, you have full exclusivity. Even if no one wrongfully appropriated your information, if they develop it on their own and you got there first and you perfected your rights, you're good. With trade secret protection, that is not the case.
Okay, so really trade secret protection is just, it sounds to me like I would just use it to protect my idea or the way that it was developed with the people that developed it. When I'm showing it around, the trade secret protection is really limited. Is that what you're saying?
Well, you can draft your documents to broaden it so that if you go to someone else to pursue distribution activity or manufacturing or other modification activity, you can get them to agree, of course, if they will, that they will not independently exploit this material without some payment to you.
Okay.
That is certainly done every day.
And it may be the same situation where there's some companies that will allow you to present them with trade secret material or non-disclosure agreement. Some will sign it, some won't. So you take that risk. If you do have protection, it makes things a little bit more comfortable. If you have patent pending or if you have a patented process that includes claims of your app, or you don't. I mean, that's really what it comes down to. You may have a great name and you try to exploit it, as you say, or try to commercialize it with a name, but somebody can come up with a different name and come up with the same type of concept. So I guess it's tough. It seems like it's tough, Marty, for a mobile app. I don't want to discourage inventors, but you want to be able to come up with something, and it's simple enough for you to do on your own and be able to put out there. I'm saying it's tough to present to companies and protect yourself, but it is possible to be able to get some sort of intellectual property. Or you come up with this app, you go to somebody, you work out an arrangement with them, you protect yourself with them with the non-disclosure agreement, trade secret, maybe a work-for-hire type of thing. Then you have them develop your app, and then you can go on, and I've seen people do it. You go on and forget about intellectual property at this point. You're taking your, hopefully you get something, maybe for the trademark, the name, or something to be able to have an asset for this. And you go on to these platforms with app and Android and BlackBerry, and there's a place there that says, do you have an app? Send it to us. And then you share in the revenue of being on their platform. But once you put it on their platform, Marty, I've heard that there might be limited opportunity of protection because you have to send them the open code to be able to put on their platform. So really, what's the purpose of having intellectual property?
I think that's a little bit of a generalization, and I wouldn't go as far as you've gone. There is no such thing as a perfect IP protection strategy. That is true. The fact that there's all the litigation we see in this space speaks for itself. On the other hand, there's a lot of value in a customized IP strategy that can range from simple non-disclosure and assignment agreements all the way up to full patent protection. Mm-hmm. It depends on the particular circumstances. As I mentioned earlier, something is invariably better than nothing. If nothing else, if you take even preliminary steps to protect yourself, you are more than likely to dissuade people from trying to steal your ideas. You can't guarantee that no one will take liberties with you, but if you do nothing, it's just like leaving your front door totally unlocked. You're encouraging amateur burglars to come in and take whatever you have.
Understood.
If you have even a rudimentary lock on your door, you're at least keeping away the amateur burglars. in limiting your exposure to the more sophisticated ones.
Understood. And I say this because, Marty, there's people that the listeners out there, when you're talking about and we're discussing this mobile app or this app world type of experience, they could be thinking, or it could be on their mind that they're thinking of a gaming app like the Angry Birds or whatever, or they could be thinking about the Walgreens type of process, or it could be something that is connecting other phones together with other phones, or printing out of space and faxing and all these different applications that are out there. So when you do have a process, it's something, it sounds to me like you're able to have a little bit more of a chance at protecting it as opposed to having, let's say, a game. Does that sound right, Marty?
Yes.
Okay. And I hope you don't mind, I'm challenging you because these are things that I've been thrown at for years, and I'm just saying I got to get some answers to the inventors out there. And I know that I'm sure you've been approached by inventors and companies, corporations, looking to protect some kind of intellectual property of their applications that they're looking to move forward with.
Yes, and that's why I stressed at the beginning of this show that the term IP is not a monolithic term, that there are all sorts of different strategies and techniques that can be used in particular situations, and that's why it's important to speak with someone who has a full toolbox, if you will, and can use tools that are appropriate in the particular case. There's an old saying that to someone with a hammer, every problem looks like a nail, and I think one can easily fall for that tendency here. You can't just talk about IP protection in a vacuum. It's a question of what IP protection is appropriate given the subject matter, given the marketplace, given the timing, and given the available resources. There's no one strategy that fits every particular situation. That's where someone who's had a lot of experience and is conversant with the statutes and the cases in the marketplace is very helpful.
Do you think that inventors can go to any patent attorney or agent to help them with protecting or getting some sort of, or coming up with the strategy, as you mentioned, for a mobile app? Or is it something that you have to go to a specialist for that specifically covers, I guess, is it called digital, some kind of digital type of intellectual property?
I would certainly want someone who has some experience in the digital world. Certainly there are different types of patent attorneys. In our firm, we have people in all areas, whether it's mechanical, chemical, electrical, you name it. And you want someone who has significant experience in the world of computers and mobile devices and has kept up with technical developments in that area and has kept up with legal developments in that area.
Okay. And when you're going to these platforms and you're uploading your open source coding, I guess it's called, or the coding that you have to the app platforms, I guess that's what it is. When you're putting it on there, you have to put it on as open source code for them to modify it to be able to work for their platform. Is that right?
Not altogether.
So
the term open source software is a term of art, and open source software is code where the specifics, the human readable source code, is freely distributed to anyone, as opposed to proprietary software where that source code is kept in confidence. Now, open source code is still subject to a license agreement. There's some generic type of licenses, such as the general public license and the artistic license, just to name a couple. There's a few dozen of these things. But you don't have to use an open source model to make your code available. Many people do, and there's all sorts of technical and commercial considerations that come into play. But open source code is a very specific term of art that is appropriate in some circumstances and not appropriate in others.
Okay. So I want to upload my app that I just developed with some